We have another big story this week that you wrote, actually, Jake, on the Ninth Circuit. There's a big ruling out of the Ninth Circuit.
That's right. Certainties in life are death, taxes, and Second Amendment or a gun control law being upheld out of the Ninth Circuit. And sure enough, this week, the California's magazine ban was upheld after listeners may remember, if you follow this issue at all, back in 2019, a district court judge, Roger Benitez, who's become sort of famous in Second Amendment circles, struck down that law and said it was unconstitutional. And then a three-judge panel in the Ninth Circuit agreed with that ruling and said it was upheld that striking down. But an en banc panel at the Ninth Circuit just ruled 7-4 that no, it in fact is a minimal burden on the Second Amendment and therefore is allowed to be upheld. Something you pointed out that is important to note, this isn't just your typical magazine ban. Like, for example, in my state, Colorado, we have a 15 round magazine limit, but folks that purchase magazines before that exceed that limit are allowed to keep them. Well, in California, they made it actually illegal and punishable by prison to retain possession of magazines that you lawfully purchased before this law went into effect. So it's just that added step.
Right. It's a confiscation.
Yeah.
That's just what it is. That's what this is. Maybe they're not rounding people up and going door to door to collect these magazines. New Jersey did the same thing, right? But this is still a confiscation law. It's illegal for you to possess them, regardless. Even if you bought them legally, you can't possess them. So it's a pretty big deal. It's a pretty extreme move. I believe there's only one other state that has a law like this, which is New Jersey, which is also being challenged and now waiting for the Supreme Court to potentially act on it. But yeah, you had we got two quotes here. First one is from the majority opinion, Susan Graber. I don't know. Sorry, Judge. Nothing in the record suggests that the restriction imposes any more than a minimal burden on the Second Amendment right to keep and bear arms. Similarly, the record suggests at most a minimal burden, if any burden at all, on the right of self-defense in the home. So that's the court's, the gist of their opinion on this case. And then you have a dissent, right?
From Judge Van Dyke. There's some pretty fiery dissents in this case. If anyone's interested, we link to the opinion, read the piece, and go read the opinion, because it's very interesting to see judges on the same circuit kind of throwing shade at one another for their rulings. Yeah, he
didn't
pull any punches.
He wasn't very polite in his response.
This quote here from him he said, "The majority of our court distrusts gun owners and thinks the Second Amendment is a vestigial organ of their living constitution." He said, those views drive the circuit's case law, ignoring the original meaning of the Second Amendment. So, I mean, not pulling any punches there, basically saying no. And he had some statistics to back it, to be fair, whether or not you think that's polite or not. He talked about how the court has a 50-0 record in upholding gun control laws in the Ninth Circuit. Basically, he says it's dubious to claim that they're simply doing an impartial analysis if it always ends up coming out one way.
Yeah, it's a fair point, right? He says further, looking at our court's cases, you would assume that any burden on the right to bear arms is presumptively permitted. I've described before how our court's version of Second Amendment, quote, heightened scrutiny has no height. It is practically indistinguishable from rational basis review. So these are legal standards that he's talking about, but basically rational basis is the lowest level of scrutiny, where as long as you can come up with some rational reason why the law can exist or should exist, then it's constitutional. Whereas even with heightened scrutiny, you're supposed to go beyond just that. But he's obviously accusing the court of not doing that. So, in judge terms, that's pretty harsh.
And it brings up a
thing to say.
It brings up an interesting point too. I mentioned this in the piece, how we talked about in previous pieces, how the court is at least flirting with the idea of getting rid of the scrutiny balancing tests for reviewing Second Amendment cases. So there's a possibility that they'll set a standard in the future for other courts to follow. And because of that, most other courts around the country right now have halted Second Amendment cases because they're waiting for the Supreme Court's guidance, because they may set a new standard that they have to take a look at. Well, not the Ninth Circuit. They went ahead and heard the case and decided it under intermediate scrutiny, which, like we've said, it looks like the court is not going to favor going forward. So I think it's interesting that they went in and upheld the magazine ban under a standard that is likely not going to exist in the future.
Yeah, I mean, we'll have to see if the Supreme Court keeps up its pace of taking gun cases on a regular basis, because they've taken 2 of the last 2 years. Are they going to take more? That's what it's going to take for the lower courts to stop doing this kind of approach. I think, the Ninth Circuit, obviously, the majority of judges on that circuit believe this is the proper standard for review and that the government deserves a lot of deference when it comes to gun laws. So if the Supreme Court doesn't feel the same way, they're going to have to make that known, probably repeatedly, to the lower courts. So we'll see where it goes. I think what happens in Bruin, the gun carry case out of New York, will probably determine a lot of what happens with this case moving forward. So
I think that's right.
It'll be interesting to watch, that's for sure. And it'll be interesting to see how California actually goes about enforcing this law, too, because in New Jersey, for example, when their confiscation bill went into effect, literally no one turned in a single magazine to the state police. So a lot of times these laws end up being more symbolic, or they end up being used extremely arbitrarily as tack-on crimes to other more serious crimes. But then you have a situation where you have millions of people likely having a felony hanging over their head. So that's never a great scenario. Yeah. Arbitrary enforcement is never a proper solution to poor lawmaking.